Well, welcome to session 3 or module 3, week 3, whatever you want to call it. This week we're going to be talking about things you probably haven't been involved in the past, board of directors, advisory councils, agency, etc. We're also going to look at the ethics of the areas, so I think you can find a lot of new material and probably learn a lot more about what your role is in your organization when we talk about the agencies. And probably the best idea is to start with agency. Well, let's start with the goals of the module. We're going to describe the roles of members of the board of directors for corporations. Again, board of directors are only found in corporations. It can be a C Corp or an S Corp. Then we have advisory councils for businesses, which can be on any type of business, including sole proprietorships. And then we're going to take a look at understanding the fiduciary nature of advisors to businesses. And part of that is dealing again with agency. And finally, discuss the ethics issue involving all board and council members. And I think that now we can start with the agencies. Agency is something that you're all involved in, and your career. And unfortunately, most people in the financial planning community really aren't quite sure what it's all about. And we're going to try to straighten that out for you in this next few charts. So let's go. The law agency is a law of commercial law, and in commercial law, agency plays a very big role. We're going to be discussing the American use of the term agent, and it has really 3 requirements. First of all, it's either contractual or quasi-contractual, means based on the circumstances, and also non-contractual agreements. So anything really can be involved, but it is a contractual type of relationship, whether formal or informal. It includes an agent, a principal, who the agent works for, and a third party. You have to have all 3 parties. And then finally, the scope of, and the agent can only act within the authority issued by the scope. If they're exercising outside the authority issued by the scope, they are not really authorized to do the work. And finally, on this chart, we talk about fiduciary relationship. Agency is always a fiduciary consideration, and even if it's gratuitous agency, you still have fiduciary responsibilities. And again, its responsibilities depend on who you are. If you're just an individual layperson, very little is required of you. If you're a professional, such as a financial planner, you have a great deal required of you. So it will vary on the level of fiduciary responsibility. We have different types of agents. We're going to discuss those in the next few charts, but let's start off with, first of all, the agency, again, consists of an employer, the client in some cases, and third parties, and you could fill any of those roles. If you own the company, you're the employer. If you're not owning the company, you're going to be an agent for the employer. You're going to be an agent sometimes for the client, and sometimes you'll even be an agent for third parties, all of which are roles that you will play. And I guess there's others too, but those would be the key ones. You say, how can I be an agent for a third party who's not a client or employer? Well, you may take on a responsibility for someone who isn't a client and be an agent. And we have 5 types of agencies. First of all, in one that's been around for a long time is the general agent, and we'll spend some time on that. Then we'll go to look at special agents, which are limited in nature, and that's usually what financial planners are. Then we'll talk about agency with an interest, which is where there's a property interest in the business. For those of you on commission, that is certainly true. Then we have a sub-agent, an agent for an agent. And again, when you work for some firms, you will be an agent of an agent. And finally, employees, where the agent is employed by the employer to perform services under control of the employer. And that agency really applies for any of you who work for a company. It doesn't matter if you work for the company as a hourly employee or you're president of the company that is a corporation. Because remember, again, individuals don't own corporations, shareholders own corporations. So if you own all the stock, you still are a shareholder of the corporation, and therefore you will be an agent of the corporation. Let's start off with our general agent. It is the authority to carry out a broad range of transactions in the name and behalf of the principal. Now, many times this is the general manager of a company. It could be, again, the owner of the company who owns all the stock, but it's a corporation. If it's a sole proprietorship or partnership, it would not be a situation where you're an agent if you're the sole proprietor or partnership. However, you could be an agent of another partner. And then we have life insurance agents also fall under the general agency. Registered representatives do. And those with the general power of attorney. And the thing that all general agents have is the ability to bind the principal and or alter the principal's legal relationships with third parties. I might note that general that also includes salespeople in any field who are representing a company, and also buyers. So if you're a buyer, you have a responsibility. But both of those have limited. They're not general like you have at a very broad nature here. Special agents have authority to act only in specifically designated instances or a specifically designated set of transactions. Again, a salesman can only sell the products he's authorized or she's authorized to sell. A buyer is usually subject to not only what products they can and services they can buy, but also how much they can spend. And many times they'll have internal rules about not only how much they can spend, but how they are to spend the money. Principal appoints an agent to find a buyer for an automobile, or a seller who has a rare diamond would be the ones that are classically given as examples of limited authority. And finally, you cannot commit or bind the principal without having the authorizations. And again, special agent is usually one who is assigned with the limited responsibilities. Agents coupled with an interest, and we talk about those on commission being an agent coupled with an especially true in real estate or brokerage. If the people don't buy it, you don't get the commission. And agents also has the authority to act as a collection agent to ensure that commission is paid, which is something that most people don't realize. And you have the right to prevent action that would be detrimental to the agent. So if there's something such as someone interfering with your getting a commission, you have a right to take legal action. Surprises to many people. Subagents. These are very common because, for example, you may work for a company who is an agent for somebody else, and they hire you. Well, you'd be a subagent. And this is very common in the business world. The authority to place these agents depends on a contract between the principal and the agent. Sometimes an agent is not allowed to subcontract to other people. In other cases, they are. You have to look at the contract. Again, that was the number one of the three items on agency we discussed earlier. Example would be a trustee who hires a financial advisor. And this happens. I think most trustees today realize they don't have the technical skills and to be both the trustee, which is a field in itself, and a financial advisor, so they pick one or the other. If they pick to be trustee, then they're going to have to hire a financial advisor, which is a subagent. And legally, the principal and general agent are responsible for the action and conduct of the subagent. So you have to be very careful on who you hire because, again, the responsibility goes all the way up to the principal. And the other part of it is there's a fiduciary relationship still required because the fiduciary relationship is in any type of agency. And we finally have the employees. An employee is an agent employed by an employer to perform services under the control of the employer. Now, this is something that is very broad. As an employee, you are required to follow, obviously, the rules of the company. An agent, usually you're A job description will describe exactly what you can do, what you can't do. If you don't have a job description for you, I would suggest you ask the employer for written guidance as to what your job is, so that you know what your authority is and isn't. I think many times people will go into a government office and ask somebody for something, and the individual says, well, I can't do it, she does it. Well, what they're really saying is they have a job description and they know that their authority is limited by the job. We're not that clear-cut in industry generally. Unfortunately, people sometimes do actions that they're not trained for, and they don't have the maybe skills even for, and we just do it. Where in the government, that would be totally unacceptable, because you got to live within your job description. I think more and more companies are starting to follow the government way of having very specific tasks for you to do, so that we know exactly what you're doing. Really reduces the liability of the company, and you as an agent are in a better spot actually too, because you know exactly what you can and cannot do. Independent contractors. Not all contracts for services is creating an employer-employee relationship. An independent contractor is one who, first of all, it contracts with another to do something. Again, it's a contract relationship. Who is not controlled by the other, nor subject to the other's right of control with respect to performance of the undertaking. And you can be an agent and an independent contractor at the same time. I might note that this is a big topic when you're dealing with the IRS on independent contractors. Companies like to call them independent contractors because then they don't have to pay the payroll taxes to the federal and state government, and they don't have to collect withholding. Where the government likes people to be called employees because they get all those employment taxes, which are over 20% of salary, plus they get withholding of income tax. Because I'll be quite candid, a lot of independent contractors don't declare all their income, and that is a reality of life, and the IRS therefore doesn't get it. But when they don't declare all their income, they're also not declaring all the Social Security taxes. So it's a big issue. Basically, in the area of trying to prove you're an independent contractor, the burden of proof is on the employer rather than on the government, and you have to show where the person's acting independently. They do their own hours. They use their own equipment. They do not get supervised by anyone. Basically, there's a contract, and the contract basically says you to do ABC. You pick when, where, and how you're going to do it. That works very well for the government. But if you have controls on them, such as they're to work in your office, they're to only use your computers, they can only work between, say, 9 in the morning to 9 at night. All of these type of restrictions are going to make it more like an employee. So again, when you have questions in this area, what do? I would suggest you talk to your attorney. Your attorney can tell you exactly what you have to do in the agreement between you and the contractors. And if you're the contractor, you want the same thing. You want to have an agreement where you're not going to be charged payroll taxes, and then in addition to your business as a consultant, because quite honestly, that can get messy when you're trying to do your income tax at the end of the year. And also, it's going to make the government more apt to audit your records, which happens a lot of times, let's face it. Government interest in employee or event contractor, I want to spend a little bit more time on that because I wanted to sink in. I know when I've covered this in a classroom, this is an area sometimes we get bogged down for a long time on, because in all seriousness, it's an area that it touches both the employer and the employee, as well as the government. And the government is very involved in reviewing status of alleged independent contractors' employees because of the taxes I mentioned, Social Security tax and SDI. The Social Security tax is 15.3% between the employer and employee, or what a consultant pay. Then you have state disability tax that varies all over the place. You have workman's comp that varies. You have liability insurance for accident employees that you wouldn't have to carry if the consultant or although personally I would carry, but you don't have to. And some local governments charge a fee for each employee. For example, when I lived in I worked in El Segundo, the city of El Segundo, which is near LAX, charges each company for the number of employees they have. Where if it's a consultant, no charge. So, and if you are, they also charge for parking spaces, which is I found kind of interesting. Employees and independent contractors, a factual issue based on the types of controls over the individual by the company. The burden is always on the company and to prove he's not an employee. Of course, if I was the contractor, I would do all my assistance I can to help the employer prove this, because quite frankly, I don't, again, want to pay some work as employees, some as a contractor. I don't want to get audited. And as it mentioned, you have an interest as the contractor. I would suspect you would be more contractors than employees from many of the jobs that we have in this industry. Formality. General rule is agent contract need not be writing, but is highly recommended in all cases. In fact, I think anytime you have a relationship with somebody in a business arena, you should have a contract. The verbal just doesn't come over well. And an example of that, of course, is a partnership. In most states, you don't need to have a formal partnership agreement. It's by your actions, but at the same time, if something goes wrong, there's finger pointing, you have lawsuits, and just for the clarity of it, I would like to have a written agreement. Again, your lawyer is good at writing one that protects all the parties involved, and I would really suggest that you have the lawyer prepare the agreement rather than just sitting down and trying to come up with it, because quite honestly, you can't cover all the problems you have. It must be in writing if the agency relationship is over a year. So if you're going to have an agency relationship over 1 year in length, it's got to be in writing. In many states, commissions paid to certain agents, such as real estate, must be in writing. In some states, between companies and sales reps must be in writing. Again, I suggest it always be in writing, and I always suggest you have an end date on it. It could be 20 years, it could be 10 years, it could be 1 year, it could be a week, but have an end date on it, and just so, again, clarity is brought out. And it's obviously a good idea to coordinate with your business attorney when setting up this relationship. I would say set up the relationship with the attorney to come up with the agent agreements before you even talk to the potential agents. Let's talk about something that can be a problem for people, and that's implied agents. Of course, it declared an agent relationship to exist in the absence of an agreement. One behaves as an agent would behave, and the principle, knowing that the agent is behaving as such, acquisition allows the person to hold themselves out as an agent. I had a client years ago, had a lumber yard, and in the lumber yard, their uncle, who was their mother's brother, hung around, and when they first started their lumber yard, he was very helpful because he didn't charge anything, and he would help them set up the equipment, and he was very useful in setting up the building they had, which was in southeast Los Angeles area. But once the business got started, he still continued to hang around, and he would be talking to clients and acting as if he was one of the owners. And when there was a lawsuit later on, he was brought in as a candidate for the lawsuit as an owner, because he held himself out as such. And the two boys who owned the business never said he wasn't. They just let him do his thing. And what was important is the two boys had all their money invested in business that was not there, but their uncle had a substantial amount of money. And of course, when they got sued, he was the one who really wound up paying, even though he wasn't really one of the owners. But he appeared to be an agent of the company. And I think a good rule of thumb is anytime you got an implied agency, it is a good idea to notify your attorney right away so you can clear it up, get in writing, or get an agreement that it isn't an agency, and talk to the individual so they don't give the appearance of being an agent. Saw this once also in a restaurant we owned, we had an individual who was a father of one of the waitresses, and he was an overbearing father. He wanted to make sure nothing happened to his daughter, so he was there when she was there, and he would talk to the customers, and he basically was a very nice guy. Everybody liked talking to him, but when there was a problem, he wound up getting sued because, again, he had the appearance of being in management of the restaurant. So, again, get in writing, make sure the people who are sort of acting like they're with the company and aren't, even though they may look like they're big up to you, that is in writing, and probably your lawyer's going to say, get them out of there, which makes sense. Apparent authority, when one acts as an agent and appears to have authority, the principal can be bound, and that should be obvious. And the common occurrence when salesperson or buyers leave a company but continue to use the order forms. And my solution is very simple. When someone leaves the company, first of all, collect all the business cards they have, collect all the stationery they have, and then also announce in the newspaper that they've left the company. Or what typically you do is say that John has gone to find new challenges for his career and has left our company, so that the general public isn't given notice that they can't represent you. I've had two cases, one with the salesperson who left a agency and continued to take the cards, and he sold policies, life insurance policies, and got the company all screwed up. He wrote about 30 policies at ridiculously low rates, and of course they weren't valid because the company has to sign it first, but it got a lot of people mad at that insurance company. The other is a case of a person who worked for a manufacturing company as a head of procurement, who left the company, was mad, so he, after leaving the company, started issuing purchase orders to the suppliers. The suppliers are happy they were getting all these orders in. They didn't realize he was no longer with the company. And since there was no notice he wasn't with the company, they never pulled his purchase orders from him that he had. They never took away his business cards. The company became liable for what he did. Serious. Yes, it is.